My name is Tejal Hansrajh, and I'm the Projects and Events Officer for 2025. Today, I'll be walking you through some oral advocacy tips. Let's start with when to concede a point during oral advocacy. Conceding a point is a strategic decision that should be made carefully to maintain credibility and strengthen your overall argument. Judges appreciate advocates who can distinguish defensible points and points that are simply weak. When you are conceding a point, recognize the weakness. Before your argument, identify the weakest points in your case and anticipate that there will be potential challenges from the bench. If a judge raises an issue that exposes a flaw in your argument, avoid being defensive. Acknowledge the weakness if necessary. Concede only points that don't undermine your primary argument. This means that a concession should be framed in a way that limits its impact. Instead of simply agreeing what the judge says, control the narrative in your favor. This approach turns a concession into an opportunity to strengthen your own argument. When you make a concession, you can also redirect the focus. After making a concession, immediately steer the discussion back to a stronger point in your argument. Don't let the judge dwell on the concession that you're making. Help them shift their attention to an aspect that still supports your case. This shows confidence and demonstrates your depth of preparation rather than allowing a single weak point to define your argument. We'll move now to how to engage with the bench. Engaging with the bench is one of the most critical aspects of oral advocacy. A strong advocate is not only persuasive, but also responsive, adaptable, and respectable. Judges will often interrupt you to question your argument, either to clarify points or even just to challenge you outright. How you handle these questions can make or break your performance. It's important that before you respond to a judge's question, you listen actively to the concern that the judge is raising. You don't need to rush to answer immediately. You're allowed to take a moment, understand, consider very critically what the judge is asking you. Maintain eye contact with the judge who has asked the question, and if for whatever reason the question is unclear, you're allowed to seek clarification on that. For example, you can ask, "My lord, to be clear that I understand what you're asking, is what you're saying?" and then clarify. Avoid interrupting your judge mid-question. Allow them to finish their sentence, allow them to finish their thought. There will be times when you start to answer and they continue their question. Stop, allow them to finish, and then answer. Don't start answering if you don't have an answer. Take a second to collect yourself, take a second to revise your notes, and then answer. It is also important that you allow the judge an opportunity to fully understand the point that you are making. Start first by answering yes or no, and then explaining. Avoid going into very complex explanation where the judge is not going to be directly answered. It's important to directly answer the question you're being asked. Try not to ramble before getting to the point. Avoid shifting the question to a different issue because the judge will come back to that question. What's also important when you're engaging with the bench is remaining respectful. This means that your tone must strike a balance between confidence and defensiveness. Judges appreciate advocates who are respectful, but are also firm in the arguments that they are making. This means that you use respectful language, you stand your ground if your argument is strong, but do so diplomatically. And if a judge, for whatever reason, pushes back, acknowledge their concern while reinforcing your point. Don't become defensive or argue aggressively. Don't say, "I disagree." You can do so, but do so respectfully. I move now to pleading with your strongest point first. One of the most fundamental principles of oral advocacy is to lead with your strongest arguments. Judges form impressions quickly, and the first few minutes of your argument set the tone for how they perceive your entire case. By starting with your most compelling point, you grab their attention, establish credibility, and shape the direction of the discussion. Judges are time conscious. They may interrupt or shift focus before you finish. If your strongest point is late in your argument, you might not get to make it. First impressions matter. A strong start builds confidence in your oral advocacy skills and makes your argument fundamentally more persuasive. If you don't begin with your strongest point first, you risk spending too much time on weaker points, falling forward, and lose time on emphasizing your most persuasive points. And a weak start could undermine the confidence in your position before you even get to the heart of your case. I move now to speak to, can you read your heads of argument when you plead through oral advocacy? One of the most common questions for oral advocates is whether or not they are allowed to read their heads of arguments verbatim during their presentation. The short answer is no. You shouldn't read your heads of arguments word for word. Oral advocacy is about engaging the bench, responding dynamically to questions, and trying to be as persuasive as possible. This can't be done if you're simply reading a written document. Judges have already read your heads of argument, or at least skimmed it. If you simply repeat what's written, you're not adding value to your case. The purpose of oral arguments is to clarify, emphasize, and defend your case, not to restate what you've written on paper. When you read your heads of argument, you create a barrier between you and the bench. A good advocate maintains eye contact and is aware of the bench's reactions. If you're reading, you're less likely to pick up on facial cues, judges looking puzzled, for example, or ones that are ready to interrupt you with a question. Engaging directly builds credibility and shows confidence in your argument. You also need to be adaptable. The court may interrupt you at any point, and if you're reading your heads of argument, you might struggle to respond to these concerns directly. Then you might struggle to find your track again. A well-prepared oral advocate can adjust their argument on the spot and emphasize what is most important. You can have your heads of argument as a reference on the side or to quote something to a judge that they may have missed, but avoid reading from it directly. The last point on oral advocacy that I will share with you today is what to have with you during oral advocacy. One of the most important things to have with you is a summary of your cases. This means that you create page summaries with the facts, the legal principles, and how it applies to your case. You do so that if a judge asks you a question on the spot, you're able to very quickly pick out the relevant case law. Another important thing to have with you when you do oral advocacy pleadings is a bundle of authorities. This means you have a well-organized collection of case law and statutory provisions that must be tabbed, labeled, and flagged for easy navigation. You can present this to the bench as well, but this is mostly for you and your partner to consult through your oral advocacy. What's also important is to have skeleton notes. What this means is that you have your introduction, a brief roadmap into what you are arguing, your strongest points, key counter-arguments, and your conclusion. This is basically a structure of how your argument should flow. The last thing you should have is a pen and a notepad. And this is to jot down everything that the judge is asking you. Should you not be able to answer it, you will answer it in rebuttals, but also to jot down what the opposition is saying so that you can tackle it in rebuttals. This will be helpful to clearly frame out your argument and to support exactly what you want to convey. I hope this helps when you are prepping for your oral advocacy competitions.